A very good afternoon to all of you. Myself, Varun Kumar, founder of Law Audience. Today, we are organizing an online webinar on the topic of mistakes to be avoided when you are practicing as an advocate. First of all, I would like to clear a few things that please do not ask any question in between the session. Secondly, and do not raise any hand. If you have any query or want to ask any question, please ask it at the end of the session. So today we have with us Harish Raichuria sir, who is currently practicing as an advocate at Supreme Court of India and at other courts in Delhi. So I request Harish sir, please continue with the session. It is over to you.
Hello. Thank you all of friends for joining this webinar. I also thank Varun Kumar for organizing this event. Let us begin with the topic of the webinar. The topic is something like this, that what mistake we should avoid while practicing as an advocate. Now here I am not going to give you any sermon. Actually, there are no right things, there are no wrong things. What I consider mistakes may not be a mistakes, but by mistake I mean that sometimes we are tempted to do certain things which look very good in the when we are doing it, but in long term it has negative effect on our profession. We suffer very much. So I want you to avoid those mistakes. I do have made these mistakes. I didn't have any mentors. I started from a small district in Gujarat. Then I moved to High Court and then I Supreme Court. Nobody advised me that you should not make this mistake. I made mistake. I suffered very much. And today, what I am going to tell you is not something read from some textbook or some other books. It is something which I have originally felt in my blood and body, and I have suffered and I have paid price for these mistakes. The purpose of this webinar is only that if some of you can grasp the impact of these mistakes, it will prevent you from making such mistakes. And this will be a great benefit of this webinar. If there is something which makes you think about what mistakes we should not make while practicing law. Now, let me begin with the first mistake. It is this mistake because of many young lawyers or law students are murdered. They are found mysteriously dead. They suffer accident. Some 10-year or 15-year experienced advocate also make these mistakes, and they are shot in the broad daylight near the court premises. For some days there are resolutions of power passed and some newspaper publicity, but thereafter nothing happens. So what these people were making mistakes. These young advocates, what mistakes they were making. Now I would like to tell you a story of a lion and a monkey. One monkey went to a law college. He became law graduate. He read great judgments of Supreme Court about liberty, about freedom, about equality, and he was very much excited. When the monkey came in jungle, he saw that a lion was sleeping in an area which was reserved only for the monkeys. He was obviously a trespasser. Lion should not have been encroached on the monkey's land. The lion was sleeping, so the monkey went and just slapped the lion and said that you are not allowed to sleep here. This is area for the monkey. You know the law? Now lion for a moment becomes stunned that a monkey slapped him. Then he stood up and roared. Then monkey fled. Monkey started running. The lion started behind him. On the way, a tree came and a newspaper was lying there below tree. So monkey immediately sat down under the tree and folded the newspaper behind in front of him so that he could not be seen. In a moment later, lion came. He asked the monkey who was reading newspaper, "Have you seen any monkey passing from this running?" The monkey who was behind the newspaper said, "Which monkey?" "The monkey who slapped the lion." The lion became very weak and he collapsed there. Oh, oh. In such a moment, this news has come in the Times of India. He felt very ashamed, and he just sat down. The monkey kept reading the newspaper. After some moment, the monkey looked from behind the paper. The lion was still there. The lion uh, immediately jumped on the monkey and killed the monkey. Now, there is a great meaning in this story. When we are equipped as a lawyer, we have a warrior mind, we are fearless, we do not mind filing cases against the very big people. We are not supposed to become upright. But this atmosphere of fearlessness is only inside the courtroom and so far as we are doing our duty. But the moment we begin to go in our own way, we start picking up quarrel with the big people, with mafia people, by filing PIL, by filing some public interest litigation. Immediately we get newspaper. Newspaper will print our stories and photo. Everybody will praise us that yes, you have done a great job. You are a very brave person. But what will happen after 3 months, 6 months? Everybody will have forgotten, but your enmity with that rich person will remain there. Then the revenge or payoff will come. And then many young, I have seen law students against whom revolvers were fired, junior advocates who have been murdered. I have seen murder of RTI activities or about for 50 years advocate who was very strong fighting against the mafia, filing cases without fearing anybody. But all this person were making a mistake which is described by Robert Greene in 48 Laws of Power. The mistake described by Robert Greene is know the person with whom you are dealing. Know the person with whom you are dealing. You do not just start fighting or start filing cases. Now, how I have made these mistakes, in within 4 months of my becoming an advocate, I had filed a criminal complaint in public interest on certain thing. Consequences came and attempts were made to murder me. Somehow I survived and today I am talking with you. But there were serious attempts, some letters to some big persons and some letter to Supreme Court saved me. But I don't want you to do such mistakes while filing a public interest or some that type of things. Be very, very careful. We have a family. We are not very rich. We are coming from a normal family. We should practice as a normal advocate. We should not go. We should not do the mistake which the monkey did in slapping the lion. We should not slap the lion. Even I have seen there was an NGO in New Delhi. The main person of the NGO was uh, filing public interest litigation in Supreme Court against the multinational brands like Coca-Cola, Thumbs Up, and so many others, and so many other food items which are being sold in India from international companies. According to these activists, these are substandard items. In foreign countries, these are banned, but in India, these are being sold. They should be prevented. Now, what happened? Supreme Court issued notice. Some orders were passed. But one day, this when activist was walking near the garden, some car ran over him. The person survived, but thereafter, I do not see much filing from him. Now, on the other hand, we have example of MC Mehta, environmentalist lawyer. He started practice from Rajasthan. He started by filing public interest petitions for local against local municipality bodies, against so many local things. Then he went to uh, come to practice in Supreme Court. Here he also filed many petitions on pollutions. Many laws have been laid down, and uh, he has been also received international award. But you look at the nature of this MC Mehta, he was always polite, non-harming to anyone, will not say any harsh word, will not pick up any fight on his own. He will simply put a general issue before the court that there are data published by a certain public institute which shows that something is wrong. If you want to do, then you do. Otherwise, he has nothing to argue. So he was very humble, never aggressive, and that's why he never incurred enmity with any persons, even if his petition or filing against very big persons, and Supreme Court was dealing with many big issues. But these people, because of his nature, he was always humble, polite, never intent to harm anyone. He was bona fide in doing good to the people, and that's why he survived. But these things I want to keep you in mind when some thoughts come to you that let us file PIL on this issue, PIL on this issue. You see, every PIL has somebody has to pay for it. Suppose you file PIL that in hospitals certain wastage are not properly disposed of. Suppose if you succeed in PIL, the court will direct large number of hospitals to install these machineries for clearing the wastage and everything. Those machinery maker will make profit, but the doctors and hospital will have to pay a large amount. So by simply filing a petition, you are causing a large financial loss to somebody in PIL. These are the nature of PIL. Now here you should remember the Newton's third law, that actions and reactions are equal. When you harm somebody, somebody can also harm you equally. That is the law of physics. So best way to do a practice of law is be a normal advocate. If some clients comes and file your case, you file it. If clients, then if any pressure will come, it will come on the client. I had filed a PIL on behalf of a person against a big company. Now immediately the pressure came, the company sent thugs to the house of the client, and the client brought me to withdraw the petition. So I withdrew. But here the point of pressure is the petitioner, not you. So whenever I have filed a petition, I have filed objectively as an advocate. Some clients whom I am not going to search, they came on to me on, and this suggestion, you file this, I put it my paper before the court and let the court do. So I was not uh, incurring any enmity with anybody. So point which I wish to make is don't make enemies in the beginning of your career. First, you become financially sound, become sound in knowledge of law, and then when you have some stature, some lot of money to fight back, then you can go against the big fights. But in the young age, as a junior advocate, you should be very careful about this rule that know the person against whom you are filing the case. In fact, I have seen many senior advocates, when a client will come, they will first see against whom they are filing case. Is it going to injure them in long way? If it is so, then they will simply say that my fees are high, you will not be able to afford it, go to some other advocate. Now, same thing is done by almost every judges which I have seen. When they open a paper book, first they read names of parties, who are the respondents, who are the petitioners. Thereafter, they try to examine the case. So they are following the rule described in the book of Robert Greene, which is book called 48 Laws of Power. The rule is know the person with whom you are dealing. So this is my one point of this seminar. Now let me come to a little more uh, general issues that when we start practice as a lawyer, there are three areas in which we can make mistakes. We can make mistakes by making submissions to judges. We can make mistakes in dealing with the other side advocate. And then we can make mistake in dealing with the clients. These are the normal three areas where we may do some mistake. Mistake here means something which looks very attractive when we are doing it, but in long run it is going to harm us. That is what I mean by the word mistake. Now, why should we be careful before submitting to judges? Why should we become careful in taking truth to the judge or speaking bluntly to the judge or making him angry? There is many views. Some lawyers say, yes, we are bold, we should not afraid of the judges. We can send, but they are always very big lawyers. So far as the junior advocates are concerned, I would like to explain you how the judges and lawyers work. You remember one thing, that judges are always a minority community. In court, there may be 1,000 lawyers. Against them, there will be 20 judges. So 20 judges will feel that we are in minority. Now you should read some books on psychology to say how minority minds work. Whenever some label is given to some people that you are belonging to a minority community, they become consolidated and they become suspicious of everybody else, others. So judges are in minority. They are a little apprehensive of almost all lawyers. You see, a lawyer can harm a judge in three ways. A lawyer can make complaint to the superior judges that this judge is not functioning properly, he is not impartial, he is giving some favor to somebody, he is taking some bribes from somebody, like that complaint a lawyer can make. Then lawyer can ask his client to make complaint. Lawyer will not come in the picture, but he will ask client, you write letter to the Chief Justice about the judge. So judges fear that part also. Then judges fear the false complaints. You see, in every bar rooms, there are few lawyers who always insist that whenever they appear in the courtroom, the judge is bound to give them order. They have such ego because of the wealth or because of their stature, their experience, their connection with the higher judges, other judges, whatever may be their backgrounds, we do not know. But when such judges are refused interim order, they don't take it lightly. After 15 days or 1 month, they ask some rug client to make a false complaint against the judge. So judges are afraid of these three type of complaints from lawyers. So how judges deal with them? Judges hold a weekly meetings In every week, judges sit for a lunch or some other parties. They sit together and they discuss about other things. They also discussed how certain lawyer behaved with certain judge. Now here is the something which you should guard. Suppose if you have hurt one judge, he will obviously discuss it with other judges that be careful of that lawyer. Yesterday he insulted me in court. He behaved in this way. So every judge in the court will be knowing. So when this lawyer will appear in other before other judges, there also he will feel a sense of hostility. Now, when judge is hostile to you personally, and he doesn't look to you as if he is some apprehensive of you, it is not good for your client. Judges should feel relaxed when you are appearing before them. But if the judges know that you are insulting other judges, then he will also feel that you may insult him also. So he will try to be careful with you. Ultimately, your practice will suffer. So this is my advice, that do not hurt any judges. Then do not hurt any judges even by asking some client to make a complaint against the judge. Judges have resources and they are going to find out that who was the lawyer behind this client who has made this complaint. So again, that will be known to the all judges. The judges will be apprehensive and it will not be good. Now here again, some of you will differ. Some of you will say that we disagree. It is okay if you disagree. You can learn by experiences. I have learned this, that if you hurt one judge, other judges will know, and it will not be good for you in long run. Another thing is about misleading. Now, judges are very apprehensive about the lawyers who mislead them on facts or on law. Sometimes the lawyers are not well prepared. Sometimes they are very eager to get orders. So sometimes they make bad statements. Judge does not verify and judgment comes wrong. Then judge feels very hurt. Recently an incident happened in Supreme Court. In some gratuity matter of teachers, Supreme Court gave judgment that gratuity act is not applicable to the teachers of Gujarat. Judgment will become reported. Now everywhere reports began to come that this judgment was wrong because the lawyer was arguing did not cite a subsequent amendment in Gujarat law which permitted gratuity to teachers. So obviously the judge were misled, they gave wrong judgment. Next day or after 2 days, the judges immediately stayed their judgment. Then they reviewed and corrected their judgment. But here this is a clear case of a misleading a judge, whether innocently or purposely, it does not make any difference. The moment you mislead a judge, you fall from the grace of judges. And all the judges will know of that court that you are citing some overruled judgments, you are hiding some, you are not checking law letters properly. So they will not give you a reportable judgment. In your matter, suppose there is justice in favor of your client, they may issue notice, they may keep your final disposal, and then they may pass a short order in your favor of your client. But they will not make it a reportable judgment saying that Mr. Haresh Raichura has argued such a point, he has vehemently submitted this, that this is the way. This he will not write because he knows that you have misled some other judge. So misleading judge intentionally or unintentionally should not be done. You had no intention to mislead is no defense. You should be very careful about your facts and about your law, and your submission should be always correct. Whether you lose or win case is not important. In Supreme Court also once happened, this is a very interesting. A lawyer misled a judge. Okay, the judge caught him misleading. Case was dismissed. But subsequently, the judge wrote down in the some file that this lawyer misleads the court. Now, thereafter, for many years, this advocate tried to become a senior advocate. He was always arguing best, like a best senior advocate. He was preparing best, submission, everything were best. But because of that remark of one judge, even after that judge retired, the remark remained on the file. For many years, he was not elevated as a, he was not designated as a senior advocate at Supreme Court. Then after many years, some Attorney General requested Chief Justice to forgive this man, and then he was designated as senior advocate. But after being designated as senior advocate, till today, he has not given up his habit of misleading the judges. He often mislead judges. He often caught by the court that you are misleading. But it doesn't matter to him. It is in nature to mislead the judges. So what is happening? I am not seeing nowadays him in Supreme Court. He is most of the time arguing in some tribunals or in some other courts. Rarely appears in Supreme Court. The reason is the judges in Supreme Court know him that this judge, this advocate misleads. And maybe in the tribunal where appearing, he is appearing, there also judges may be knowing. But there may be many such instances. But point for you is that judges may be keeping a file on you. Maybe they want to elevate you as a judge. Maybe they want to designate you as a senior advocate. Or if they consider you as a nuisance element, then there will be some file in the court somewhere before the registrar or somewhere where your mistake will be recorded, and it will hunt you through your entire career. Whenever a question will come up whether you should be designated as senior advocate, no, that file will come in the way, and your whole career, promotion, your dreams, everything will be destroyed for one mistake. There is no forgiveness here. I repeat that be very careful, assume that your conduct or mistake will be recorded in some files. Now everybody is keeping files. You see, I give you example. In High Court once, when I was practicing in Gujarat High Court, one day I saw an old friend. So we talked. He said, "What are you doing?" He said, "I am now a law secretary in Gujarat government, and I am now observer here." I said, "What do you mean observer?" I said, "We go in the courts, there are 4 to 5 observers. We go in the different courts where cases against government are going against it. If some judge speaks against the government, against the chief minister, or like that, then in the evening we have to report it to the law secretary that look, certain judge is speaking against the chief minister, speaking nastily against the government, behaving rudely with the government officers." So that will be recorded in the file of that judge. Now, even company, there are nowadays many companies who are keeping watch on the judges. They are keeping files on the judges. Let me say, I was specially going to Ahmedabad to argue a case of a company. Now, every time I went in the Gujarat High Court to argue that case, in the last row of the court, I saw two person, one looked like a thug and another like an officer, used to sit there regularly and keep watching every word I was speaking, every word judge I was speaking. So one day after hearing during recess time, I directly approached them. I asked them who you are, why you are sitting here in every date of this case. They said we are from this company, which is opposite party in your case. So I understand that these big companies are also keeping files on the judges. If the judge says something adverse against the company, it will be recorded in a file. And when a judge retires, after his retirement, arbitration works of companies are referred to the judges. Now, judge in worst files, some negative reports are made, will not be accepted as arbitrator by the company. That will be a revenge of the company for speaking some wrong words against the company, for giving some wrong judge against the company. So this is how what I am trying to say, that be aware that you are being watched. Judges may be keeping file on you. If you are fighting against the company, company may have a file on you. If you are planning to become elevated as a judge, then be assured that there will be some file. Some judge must be recording good or bad about you. Suppose you argued well, then also they will record that this advocate has argued well. It will be talked with other judges that young advocate, lady advocate, or that gents advocate is arguing very well in my court and deserve to be encouraged. This will be discussed in the meeting of the judges. This is my impression. So that advocate will be sponsored or say encouraged in wherever he will go, because judges will know that this advocate argues very well, he is well prepared in law, he is well prepared in facts. So his reputation will be there. So you are being watched. If you are going to, if you have ambition to become designated as a senior advocate, or if you want to be elevated as a high court judge, then be sure that some file is being kept. Always be courteous and as proper as you think fit for your purpose, and avoid making mistakes which may come in your way in future. Now, after misleading part, we come to the taking cases of relatives or taking cases of very rich person. In the course of your practice, you will many times in the early years also relatives approach us. And suppose if we take cases of relative, we become emotional in the court, and that does not augur well. I remember a case, a lawyer has taken maintenance proceeding case of her cousin who was husband in this case. And during the argument, he became angry with the judge. He hurled abuses against the judge. The judge reported this to the High Court. The High Court took suo motu contempt petition against that advocate. Then uh, he was convicted. His appeal came to Supreme Court through me. That appeal was also dismissed. After some years, I learned that he had died because of the blood poisoning which he had taken. So be careful when you some relative ask you. Doctors, about doctors you may have heard that the doctor will not do operation of his own son. Emotions come in the way. In the same way, lawyers should not take their own cases, should not fight their own cases, should not fight the relative cases. Here, the objectivity goes, and we may suffer personally as well as in court. So, better to give it to some other lawyer. But this is my case, you fight it. And then We are again, yes. Here, some of you may have a question that what if the judge insult us in the court? Should we not reply to him? If we will be so submissive to the judges, will they not become arrogant? Will they not become corrupt if they do not fear us? Should we not become a fearless person? There can be many answers for this, but I am now in my mind is junior advocates. For junior advocates, I give this advice that always wear a raincoat when you enter in the court. If the judges say something wrong to you, assume that they are raindrop on your raincoat, come out from the court and forget about it. Do not escalate the situation because we should consider our position when we are junior advocate. We are still struggling to make our name in the profession. Then we should not go into larger issue whether lawyers should be brave or whether judges should be brave, whether judges should maintain decorum of the court, or whether lawyers should maintain decorum of the court. These are issues for big lawyers to consider and examine. It is for them to uphold dignity of bar and dignity of court. They will think. But so far as junior advocates are concerned, my suggestion is wear a raincoat when entering in court. Don't worry, whatever judge may be, he may be angry because your client may have be uh, convicted for carrying 50 kg of narcotics. Who judge will be kind to such a client? He will become angry when the more you will argue, the more judge will become angry because the case is a foolproof according to the judge. He has some mindset that these drug peddlers are doing damage to the society. Why lawyers should take such cases? Many things can happen. I remember one case. A lady advocate appeared to argue case for a rapist. Now, the moment she said that I am appearing for the rapist, the judges were a little taken aback. But then during the argument, the problem came with the judges. They wanted to ask counsel to read what the rapist has actually done to the uh, victim. Now, this part this looks very bad if a lady advocate read it in the open court. So judges said that you should not have taken such case. So after the case was over, there was a discussion in the women bar that how judges can tell women lawyer not to take cases of rapists. Judges were wrong, they should not have said. Such things can happen. Once a judge remarked because some advocates were not properly dressed. Sometimes a lady advocate was not improperly dressed. They just made some remark. But these things are a part of life that it kept happening in the court. Suppose you are in the seat of judge, then you are not bound by anybody. You are a human being. You are willing. You have freedom to express your anger. You have freedom to express your views apart from deciding the case. Court system is not such that judge should fix to the what is being argued and what is the judges are human being. They now and then say something, so don't take it personally. It may be related to the client, what judge may be saying, because your client may have duped crores and millions of rupees of client of public. So judge may be angry at you also. But his anger is usually for the client. So don't take it personally and wear a raincoat, come out from the court smilingly and go to the next course. That should be the attitude of lawyer. Now I am, yes, I have, oh yes, in trial court, in high court, everywhere I have faced this situation that be very careful when you are fighting against some very big lawyer, big shotguns in the bar. They can personally harm you. If you try to take case against them and fight against them in such a way that, you see, we should know the person with whom we are dealing. I remember the very first case when I was a junior advocate, a tenant came that a landlord has filed suit and he paid me 300 rupees for fighting the case. I took the case, I read the case, then I talked with the client. Client said the advocate of plaintiff is a land grabber, property grabber. He files suits on rent cases, then purchases property from the landlord at low price, then evicts the client, and this way he is collecting property. So he is in fact a property dealer in grab of a lawyer. Now this shocked me because he was the top lawyer in the bar, highly reputed, and he was also in the co-opted member in the disciplinary committee of the bar council. Next day I called the client and returned the brief that I don't want to take your case. I am a too young lawyer. I have just joined the bar in 1 month. I don't want to make big enemies. So please take your case paper back and please take your 300 rupees back. That was, I acted at that time in 1982 when I had just joined bar. Even today I am not sure whether I did right thing or wrong thing. You should not also judge whether it is the right thing or wrong thing. But the issue is when I am struggling to get cases, I am struggling to get seniors, I am struggling to settle myself in profession, I should not start making big enemies. That was my principle. And even today I follow this principle. I avoid making enemies. Then I would like to say, yes, many law students and many uh, junior advocates fell in the trap of reading some law which contains mistake, apparent mistake. The law is ultra vires the constitution and some provisions are bad and they want to file a petition challenging that ultra vires. In hope that if I will be able to set aside this law, I will become famous and I will start getting case. Now I wanted to warn you that when you are a junior advocate in High Court, you may have a good point, you may have validly challenged the law, but I am not sure whether judgment will be ever seen in your case. It happened in my case. There was a Benami Properties Act came. I was at that time High Court. Certain provisions were bad. I immediately challenged the provisions in High Court. High Court admitted the matter and issued rule. Rules mean it may come in due course. So it may come after 5 years or what. That was so. So I didn't get immediate publicity or any benefits. Now in 5 years, the Supreme Court already somebody filed a petition and set aside that provisions. It was exactly on the same ground which I did. The difference happened in this way. that you do not get publicity by filing PILs and do not get professional benefits in filing PIL, that clients will not start coming to you by reading your newspaper that you have been part in such a PIL. So that doesn't count with the client. Client has some cases. He is looking at your winnable ability in this case, particular his case. Nothing other things impress him. And all these newspaper and press publicity, they were forgotten within a week or so. So at one time it was great to see one's name in the print, but now it is not so. So don't be swayed by the PIL filing moods. That is not paying, that is not being publicity. You may have heard that certain law student filed a PIL in Supreme Court, and PIL was allowed by Supreme Court. Section was set aside by Supreme Court. But there must be behind those law students some very top senior advocates suggesting, arguing for them, or settling draft for them. The background force must be there. If you and I are ordinary people, we should not uh, dream for an overnight publicity through some breakthrough case, a rainmaker case or something. Rainmaker is the John Grisham's book. I had read that. The hero in the book filed a case, won a case. It was a rainmaker case. Lots of money have to be paid to lots of litigants by the companies, insurance companies. But in the end chapter, what happens? The advocate who fought the case or his partner did not get much money. They did not get any financial benefit for that. That you fought such a long, strong battle, and even then reward doesn't come. So here the uh, Lord Krishna's Bhagavad Gita principle comes that you do not have right to claim rewards of your action. You keep doing your actions, but if you are looking for reward first and then doing, then there will be a long series of frustrations. So this was about those who keep finding mistakes in the laws, what is arbitrary, what is, and to challenge about them. That stress should come after you have practiced some years. But in the young age, do not go about challenging the laws and like big things. At least it did not uh, help me in any way. I have also got some reported judgments, but if unintentionally some cases come and you argue well and it is reported, then it benefits. But if you purposely go and seek for publicity and therefore you go for some issues, then it does not pay. It does not work that way. Happiness and luck both are like this. The more you try to search for it, the more they run away from you. If you sit down at a place, then happiness will come automatically and prosperity will come. You should sit down at a place, calm down. If you chase, then the thing go away. Chasing is very bad. That is of course my view. Yes, then now and then some clients will come to corrupt you. For example, in about 4 months ago, I received a call from an American client. He has given case to somebody. His case was going on Supreme Court. He said, I have heard that some judge has a good regard for you, and all you need to do is to sit with my judges, with my lawyers when my case is being argued. Because I am told that you have faced law before this particular judge. On the spot, immediately I said no. I told him that I had no cash law and I won't accept this type of brief that I have to just sit with your lawyers to show my face to the judge. I don't believe in this. So I rejected that. But this type of client will come to you also. Some will say that let us fix the judge. Is he fixable? Should we bribe him? Through whom we should bribe? There are a lot of lawyers. All lawyers have different views in this area. No view is right, no view is wrong. I do not say my view is right. I do not say that my view should be also your view. You can do whatever. What I am going by this Gita principle that in life we will come across things which will look very sweet in the beginning but very poisonous in the end. So I regard this as a immediately it looks very sweet that somebody is paying us a lot of money for just sitting in a court because he thinks that there is a fast law and judge will be favorable to them if I sit there. It looks very sweet, but it is poisonous in the end. So I do not go for that. And for you, you have to take your own decision. You have to, you are living in a new world to take your own decisions. But according to me, this is a mistake and I don't encourage. Then I think I have covered almost all the area which were in my mind under the topic of mistakes which a lawyer make. Mm, yes, there is one more point. Suppose a big mafia gang boss comes to you and asks you to file a case when you are still a junior. What should you do? When the mafia boss will come to you, he will be very sweet to you. He will give you lot of money. Whatever your fee demand, he will ask you double fees. But then, if something goes wrong, then you can get into trouble. And it is very hard to get out from such troubles. Many lawyers have faced such situations. There are laws nowadays that if somebody threatens lawyer, he will be so. But laws are in papers. You look at the real life, and I give you a simple example. Suppose a tiger comes and wants me to engage. Now it is all right. I take his case, but tomorrow if the tiger gets angry, I should understand my own strength. I should be stronger than the tiger to take this case. So what normally I do, if a tiger comes, I take him to a big senior who is an even bigger tiger. He can immediately kill this tiger if he wants. And then keep him with me and then I take his case. So in criminal, civil, many cases, there are things which are very top people who want to fix the system. They want to they want to control you. The moment they will pay you double fee, they will start controlling you. They will begin to think that you are his servant. And if somebody will tell him that, look, this lawyer has double crossed you, it will be a very bad situation. To avoid such situation, I would like to advise you to look at the reference from which case is coming to you. I always ask when a case comes to me, send you to me. So if there is some problem, I can tell to that person that look, your client, the client you send is now troubling me. That is why I safeguard use. That I always look for whom reference this client is coming to me, on what basis they come. For example, one client came without any reference. I asked, how did you came if you had no reference? Then he said that there was a reportable judgment case argued by me on this act. Therefore, I thought that you will be knowing fully about this act. Then I said, okay, then I accepted that case. Otherwise, if somebody knocks at my door and starts me giving case, I become a circumspect because I should know. You see, we are living in a world, such a world where people are doing things without living evidence and without being seen. I repeat, people are doing things without living evidence and without being seen. And as a lawyer and judge, both are supposed to go only by the evidences. So there is no, it is not worldly wise to go uh, keeping too much faith in the rule of law. Rule of law has its limitation. We are very strong in court when we are arguing, but by and large, we should understand the world, how the world is going on, and we should adjust ourselves to the real world situation today. Some judgments may have been, you have read some judgment of Justice Krishna Iyer, maybe 20, 30, 40 years ago or what, maybe. But he lived in different times. You are living in different times. When I am telling you about my experience, but I lived in different times. Your time starts now. It is a different time. You adjust to your times and avoid making mistakes. Making mistakes means things which may be looking very good at right now, but which may have long-term harmful consequences to us. That is, I think I would conclude this webinar. If you have any question, you can ask me. Is there any
Yes.
question?
If anyone wants to ask any question, please type your question in the chat box or you can raise your hand. So now I am unmuting Dinesh Prasad. Dinesh Prasad, please ask your question. Dinesh Prasad, I have unmuted you from my side. Please unmute you.
Good evening, sir.
Good evening.
Sir, my question is that as a newcomer student, newcomer advocate, we feel very confident. And whenever we see any illegal acts in our neighbor at petrol pump, how they are giving petrol without helmet, and anything such like that, we feel very aggressive, and then we think that we should file cases against these issues. So, what do you think, whether we should file or not?
I would like to say in this way that you have learned something in colleges and then you have come. Now you forget whatever you have learned in the college. Now
Yes,
you
sir.
see what other people are doing, what your seniors are doing, how they are doing. If they are not doing, then there must be some reason. Let us examine our train journey. Earlier, there were general coaches. In people, capacity of the coach is about 64 persons, but there are 300 persons are crushed in the one railway compartment. It is violative of law. But what will happen if you will file PL or petition? People are traveling on the roof of buses, on the roof of trains. These all things are illegal. Illegal things are thousand and thousand and millions and millions. We do not have enough judges to deal with it. We do not have law enforcing agencies. We do not have enough law police officers. We do not have enough investigating officers. So choose your battle wisely. Even Gandhiji had to think of it. Gandhiji must have been thinking like you in early years. But then he came to the point that we have to choose our battles. We should not fight every battles.
Okay, sir.
कल्प कल्प कोई खटखट आ रहा है हाँ सॉरी हाँ यस somebody is knocking yes any other question
Let me check. Now I am unmuting Akhil. Akhil, please ask your question.
Hello,
Hello, yes.
good afternoon, sir.
Good afternoon.
Sir, I am a law student of Aligarh Muslim University, second year.
Yes.
Sir, I wanted to ask that if we want to practice in Supreme Court, do we have to first practice in trial courts, or we can practice in high courts, or as well as in trial courts as well?
Hmm.
Do we
I
have
think
a
I,
choice, or we have to follow a procedure that we should first practice in trial courts, or then we have to practice in high courts?
Mhm. I think earlier webinars of the law audience, I have exclusively dealt with it. How, if you have a dream to practice in Supreme Court, what should be the problems here and how it should be done. That already I have discussed. But briefly, I can say that Supreme Court, you do not get chance to argue cases. You see, a case has been argued at length in trial court. Judges have applied mind. In High Court, it has been argued. Most of the point, the judges cannot be wrong. And after this, it is like a cancer hospital. Supreme Court is. So from this, you have to find out something, and it is a very. Suppose you are already not knowing procedures in trial court. It is not about procedure, about the real world also. How litigants fight, how they compromise, when they compromise, what happens after they get judgments, what errors judges do, what high court judges do. Unless you have learned all these things, your experience will not justify you to practice in Supreme Court. It is also morally wrong for you to start practicing in Supreme Court without such experience, because I would say why it is morally wrong. A High Court judge is about 60 years old. He has 30, 40 years experience, 30 years or 20 years experience in bar. He has passed a such judgment. A 60-year-old judge, well-read judge, has passed a detailed judgment, and you who have just joined legal field in 2 years started to argue in Supreme Court that a judge has passed a nonsense judgment, judges committed that error, that error, that error. Supreme Court judge will say all dismiss, next case. So here you will not get much exposure. Best thing is to try to get some months in trial court, then try to make your way to the High Court, and then if you really feel that you have so much established in High Court that now High Court is becoming smaller for you, that your knowledge has so increased that you ought to come to Supreme Court, that's why you should come to Supreme Court. But otherwise, you can see the previous 2, 3 webinars on the law. It will be available on YouTube on law audience website. There are only this how from I was practicing in district court, 4 years in district court, 4 years in Gujarat High Court, and since 90 I am in Supreme Court. So I have described my entire struggle in my journey. You can check up that.
Okay, sir. Thank you so much, sir, for the precise information.
Now I am unmuting Anish. Anish, please ask your question.
Good evening, sir. My question is nowadays we can see a lot of original petitions, IAS, etc., that has been filed before various courts, including Supreme Courts, are uploaded in the online law portals for sake of publicity. What is your opinion about that, sir?
You see, okay. I cannot discuss your philosophy, but Nietzsche, a German philosopher, examined all these things. He began by saying, who are who to decide what is evil and what is good? How did the definition came? On what basis you say that this is bad? On what basis you say this is good? There is no criteria, and the philosopher said that truth is like a woman. It can change in this way, it can change in this way, in the morning in this way, in the evening in this way. Just as woman's mind is unpredictable, truth is always unpredictable. So what is good and what is bad, it is not the right way of thinking. According to the philosopher, this is my way of doing thing, this is their way of doing thing. So far as the right way is concerned, there is no right way. So in your mind, it is that you are seeing that so many people are filing petitions for publicity. Well, it is they are filing, they are filing. There is nothing good, nothing bad about it. Whether you should do that, you decide whether you should do that or you should not do that. In long run, will it bring you happiness, or not doing that will bring you happiness? That you decide. And what you can do about it, suppose large number of people are filing frivolous petitions in Supreme Court for publicity. What judges can do, they can impose some cost. But apart from that, what can they do if they keep filing people? There cannot be a right answer to this question. Just examine the truth as it is, reality as it is, and adjust your own decision and your own conduct accordingly.
Yes, sir. The next question is from Archit Rana. What to do if instead of a client, an advocate is pressurized to withdraw the petition?
Play the game. Play the game means the moment you say that they are pressurizing you, means you have become some person. If your own client or your own advocate, briefing advocate is pressurizing you to withdraw the case, then don't say pressurizing. They won't withdraw, so withdraw it. You don't have to think about what is good for them and what is bad for them. It is for their business to decide. So if other side or somebody opposite side is pressurizing you, then maybe you can complain to the judge. It is wrong like that. But so if your own client wants to withdraw case, then you have no right to say no.
Yes, sir. The next question is from Bobby NV. I wish to know how can one challenge a provision of law based on presumptions. For example, Section 112 of Indian Evidence Act, which amounts to conclusive proof, as per Section 4 of Evidence Act. In view of the Section 497 of our IPC being decriminalized, I wish to challenge this presumption when the fact of adultery remains to be true.
Why do you want to challenge it? How does it affect the client, your client? Don't keep looking for the errors in judgment, errors in law. Yesterday, only we had a discussion with my junior that in Order 35, Rule 1A, there is a last rule that if something is done in violation of Rule 1, it will be void. Now, here, word void is wrongly placed. A court order can never become void. Court order has to be set aside by higher court. It cannot be void, even if it violates 38(1). But then 38, Order 38, Rule 1 4 says that it will be void if it is in violation of 1. There will be hundreds and thousands of mistakes in law. So don't go after these mistakes. If the clients, it is hurting you, judges will also decide this, if it is going to turn the case this way or that way. For academically, judges will not entertain any petition to decide whether such provision is valid or not valid. For example, I am planning to challenge certain provision in consumer court, of new consumer court, because they are affecting case of my client, not because I want that these provisions are wrong in the new consumer law. And therefore, I am not want to file PIL, but it is damagingly my client's case. So my client wants to file a case, so I am filing it. That is the way. Okay, it should be, when you challenge a law, there should be facts. There should be a lease or litigation which can turn in this way or that way. Then only judge will examine whether a section is valid or illegal. I give a real example which happened in the Delhi High Court. In Delhi High Court, a junior advocate was arguing that certain provision is wrong or certain suit is without jurisdiction. His argument was this way, that after Commercial Act came into force, all such cases transferred to the commercial court. But after coming into force of this law, if somebody files a small civil court suit, then it cannot be transferred to the commercial court. It does not get automatically transferred. There is some provision, and that's why it is, like that he was arguing. He heard his argument at length. There was some substance, some mistake in the section. But judge said, all right, I am admitting your petition, but suit will go on. Now, what does this mean, the order of judgment? It means your case will be decided after 3, 4, 5 years. In the meantime, the suit will be over. Your client will have to pay. So your whole legal academic intelligence has gone in vain. So earlier in this webinar also said, in young age, do not try to keep finding mistakes in law. Every law, there are lots of mistakes. Our laws are not very well drafted.
Yes, sir. The next question is from Divakar. He says, during several internships, I have faced this issue that the senior is late to the court, and in such situations, the junior advocate has to represent his senior in that particular matter. In such situations, if the opposite advocate is a big shot and tries to mock the junior, how shall the junior respond?
It is like suppose on one side a rabbit advocate is appearing and on the other side a lion advocate is appearing. How rabbit should behave? It is for rabbit to decide. Judge will not come in the way. It will be a battle between the lion and the rabbit. So law says that we are equal before the law. Don't take it literary. We are not equal. So point which I earlier said, play the game. Play the game which rabbits should play. You will learn this by experiences. That's why I took a very point that when you are fighting as a very big advocate, he has outside court many powers, many influencing, and not proper to make him enemy.
Yes, sir. The next question is, if the judge is favoring the other side, is it advisable to apply for transfer the case to another courtroom?
Okay. The question a lawyer should ask in such a way that will it going to help us? Will it going to help my client if I do this transfer petition? It is your personal belief. You feel that the judge is going against the other party, so you want that case to be transferred. But will it be helpful to your client? That is what you should examine. These things are happening in every day in every court. But if you will read the case law about the transfer of case from one court, you cannot ask for transfer on the ground that the judge is prejudiced against my client. There are some other provisions that there is a reasonable chance that he will not get justice. And these are interpreted in different ways in different judgments. But even if you file a transfer case, if it is dismissed, your case will be against the same judge, and hostility between you and that judge will increase. In filing transfer petition, if you will make some allegations against that judge will know. That will also increase your enmity. Client will come and go, but hostility between you and the judge will continue forever. So on earlier webinar also I said that avoid such things unless it is going to help your client or unless you are in advanced stage of practice. My webinar is only for the young junior advocates who are struggling. So when you are in struggling, you are still in process of getting briefs and settling in field, then don't try to become very brave. Don't try to become very aggressive. Aggressive legal advocacy in young age is not, I have not seen it succeeding.
Yes, Archit, I am unmuting you. Please ask your question.
Good evening, sir.
Yes.
Sir, my question is I'm interning with a reputed law firm in Haryana. So there is this client of ours. He is a very reputed person here. So what happened? We filed an appeal before the tribunal, and somehow a local newspaper got to know about it. Without knowing the facts or anything about the case, they published an article about the client, which resulted in tarnishing his image.
Defamation.
Sorry, sir?
Yes. Yes, defamation happened.
Yes, sir. So, what to do in this type of scenario?
You examine the law of defamation. Defamation law says that pleadings filed in court are not protected.
Okay, sir.
So only the orders of the court are protected. If somebody, journalist publish detail of the order of the court, then he is protected. But if he publishes the entire thing alleged in the pleading, then newspaper is not protected. Defamation claim lies against them.
Okay, sir. Thank
So
you so much.
defamation notice should please proceed with the notice and see what reply of notice comes.
Okay, sir. Thank you so much.
Yes, sir. The next question is from Anish. Sir, how to handle a situation when the opposite lawyer is a very senior lawyer and the judge is not allowing or granting time for us to present our case and we are about to lose the case?
You see, I have faced all these things. For example, when a very big senior advocate will appear from other side, many times it happens, judges will not even look at us. They didn't look at me and allowed as per that senior says. This can happen. We are living in a human court. We are in human beings. But complaining or quarreling about this does not help. You have to learn to play the game. I would like to explain this further. Play the games mean what? You are playing a cricket. You are batsman. Now 11 people are surrounded you. All of them want to uh, throw balls at you and to declare you out. And the umpire is also corrupt. Umpire also seeking an opportunity to declare you out. In such situation, you have to keep playing ball by ball and you have to keep scoring the mark. That should be your goal. You cannot complain about the umpire, you cannot complain about the other persons who are doing illegal things or improper things to prevent you from winning. These are all fielders. The umpire is doing his job. Wicket keeper, who maybe you may say backstabber, but he's doing wicket keeper job. So play the game of life. Life is a game. Court life is also a game. Learn from good players.
Okay, so let me take some questions from YouTube also. So there is one question from Pushkar. So can you please guide us in how should a junior lawyer invest his money in making library, and what mistakes should be avoided while making such investments?
Please repeat the question. I could not get it.
Can you please guide us in how should a junior lawyer invest his money in making library, and what mistakes should be avoided while making such investments?
Now, I followed one principle that I use the library of the court And after some time I started purchasing. But when I had no books and suppose a case come, I would case will naturally come with some fees will come from that fees. I will allocate some fees to buy a big commentary of that law. I will buy a big book of that law concerned to my client. This book will give me confidence. My client will also feel become confident, and I will get also good result because of the book. So when a case comes, suppose a case of rent act will come to me, I will buy a rent act book. If a case of specific performance of land will come to me, I will buy a specific performance law book commentary. Presently, I have a very big library, but in the initial year, I was purchasing books in this way. So in junior studies, we can follow this procedure.
Yes, sir. Sir, Raji says, sir, can you say something about Prashant Bhushan contempt case?
Okay, it is a controversial. Normally, I don't deal with controversial issue, but I will tell you a KL Gabba case. It is a Privy Council time case. KL Gabba was a lawyer in then some High Court, and the Chief Justice was corrupt. There was a party in the evening of the Chief Justice, other judges, and senior lawyers. One day before the party or in the morning, the KL Gabba circulated a Magna Carta, a memorandum which described how the Chief Justice was corrupt. He described 1, 2, 3, 4, 5, that how he was taking commission from the registrar on every liquidation orders and so many. There were concrete proofs and evidence. So what happened in the party, evening party, everyone began to smile at the Chief Justice. Chief Justice did not know what is happening, but by the evening he learned that his KL Gabba has circulated some defamatory, contemptuous letter against them. So next day, Shimoto contempt petitions was registered against the KL Gabba, in which that Magna Carta was never placed. The basis of contempt was not there. Simple one-line order, issue contempt. And then he was sent to 6-month jail. Here, even that Magna Carta was not in the file of court, it was not discussed, and the man was sent to jail, KL Gabba. KL Gabba made an appeal to Privy Council. Privy Council adjourned the case, and on administrative side, they asked High Court to send the Magna Carta. Magna Carta in which these lawyers make allegations against the judges. They also, Privy Council judges also read the allegations. The allegations were based on proof and everything was truth. Even then, on next day, Privy Council dismissed the contempt appeal against the contempt, and the KL Gabba remained in jail for 6 months. Now, on administrative side, the judges forced that Chief Justice to retire. That registrar was removed. Several steps were taken to purify the registry to reduce the corruption. So this is a precedent going back to say 70, 75 years ago. KL Gabba was the name of the lawyer. So what we learned from this case is this way, that suppose you find some judge is corrupt or something else, then going to public is not permitted. There are administrative side, there are other side where proper things can be done, and there are people who can pull up such judges and can correct the remedies, whatever is possible. But the moment you go to the public, the people who are coming at the doors of the court will stop coming. The people who are coming to give you brief to you and me will stop coming. The entire judicial system will suffer. So all the, if we go by the KL Gabba case principle, those who go to public about the certain corruption in judiciary or certain there, they think that truth is their defense. But you see, contempt act is not for that. Contempt, even if there was no contempt, every judge has power to punish in contempt. It is unwritten law. Because suppose you are a judge, if somebody is appearing in court and outside giving everywhere there that you are a corrupt judge, then you will not be able to function as a judge. No judge will be able to function. System will collapse. So that is why the judges are given power. But if they think anybody is unnerving them, preventing their mind to give judgment impartially, then they will contempt. There was a case when a judge had gone on a holiday on Goa. Now there somebody disrespected him, so he issued there and then contempt notice. So the case went to the High Court and everywhere, but whether it can be said to contempt or not. Judge was not on duty. How can he issue contempt? Even then, contempt proceeding were there and it was going on. The basic criteria for contempt law is this way: if anything is done which prevents a judge to function as a judge and to pass judgment impartially or to do his work, is a contempt, it is punishable. And judge has power to punish this. This is the final law of contempt. And this is in the public interest. Now, if there is a corruption in judiciary, you find out some way to remove this, but don't go to public. That is the message of this Kail Gaba. This happened in Kail Gaba case. The contemptual Magna Carta was never placed in the file of the court. Privy Council called it on administrative side. It read the judgment. It took action against the Chief Justice, against the Registrar, against other persons. Described it accepted the Magna Carta and acted on it, removed every person connected with it. But so far as the contempt punishment is concerned, Privy Council say yes, contempt has been done, and the man should go continue to live in jail for 6 months. So this is how the contempt law works. I think this should clear your mind about a little. Contempt, some people are in this way. If there is a truth, then there should not be a contempt. But this idea is not yet finally debated anywhere in the world. In America, you go anywhere, it is still a loose area. But the ultimate, all judges all over the world agree in this way. That is, when suppose you are sitting in the post of a judge, if anybody does anything which disturbs you mentally, then it is a contempt. That is my view. You may be on this side or that side. You see, nowadays people are divided in this way. This is our gang and this is your gang. Either you are on this side or you are on that side. Truth doesn't matter. So people are being divided in that way. Those people will be speaking in favor of Prashant Bhushan will be in certain group. Those who are criticizing him will be in certain group. But none of the group may have principle-based thinking. So don't go by the media propaganda, social media propaganda, or you just study the contempt law properly, why the law was enacted. Even if there was no law, every judge has power to issue contempt. Even if suppose contempt act is removed from the law book, even then judges can punish for contempt. It is an inherent power.
Yes,
Some
sir.
other day we will give another webinar on this. Contempt law is very interesting. We can find out some date on which we'll discuss it. Any other question?
Yes, sir. The next question is from Ramesh. How to deal with the bench clerk?
Okay. Again, I said don't ask that question. You learn to play the game. You are in a real world. I give you another example that how do boxers fight in the boxing ring? First, there is an instruction room where there is a coach. He gives him instruction. Okay, you will fight this way, this way. Then there is a rehearsal room when two people they keep doing rehearsals, and the actual boxing ring where nothing counts. Everybody is throwing. Two persons are fighting. They are throwing boxing at each other. This is the real world. The court is the boxing ring. You have learned is all right, is it learned and rehearsed and everything. It is outside court. Once you enter in the court, you are in the boxing ring. Your aim should be to win and to defeat the opponent. That is the only object with which you should enter in the boxing ring. So, how to deal with court clerk, how to deal with judge, how to submit to judge, how to argue, everything should be guided how to defeat. It is a boxing ring. Think in this way that you are a boxer, other side is a boxer. Try to win the case.
Yes, sir. There is no new question. So if you allow, so we can end this session.
Yes, if there is a question, you can say. If there is no question, you can end.
Okay, thank you, sir. Thank you very much for your time, and thank you to all the participants for joining this webinar. If you have any feedback, you can mail me or you can WhatsApp me. Thank you, sir. Thank you very much.
Thank you, all the best.